As Attorney Mike Gerlin coming to you from Chicago as usual, and we're going to do a fun one today. We're going to go visit our old friend Judge Olsaver in Lenawee County. This video was sent to me by Erica. Thank you, Erica. It's good stuff. I've done a few videos with him before. This is a pro se debacle, and I think you're going to like it. Let's do it.
All right, we are on the record now with in the People of the State of Michigan versus John Mitchell Stover. It's file number 21-20605-FC. Today is the date for a pretrial conference in this matter. We are proceeding today by video conference. First, let me ask attorneys to place their appearances on the record, beginning with Mr. Hartung.
Thank you, Your Honor. Doug Hartung appearing for the people today. We have no objection to the Zoom proceedings.
James Daly appearing on behalf of the defendant. We have no objections to the Zoom proceedings.
Mr. Daly, then where do we stand with respect to this case today?
Well, first of all, Your Honor, Mr. Stover wants to address the court. He does not want me to address the court on his behalf.
That is an incredibly bad move. And that's where we're at, and that's why I call this a pro se, because he is technically represented throughout, but he's handling it himself, and he's doing a very poor job. James Daly, I had on another video called the Michigan Republic, and also Judge Olsaver. I've got a playlist for him, so I'll put a link to that in the description below. But James Daly, I think, did a fantastic job. He had a sovereign citizen and talked some sense into him. And he has this sort of tired affect and all that. But I think he's a sharp guy. Everything that comes out of his mouth makes sense. And I can kind of see his wheels turning and why he's doing what he's doing. Obviously, this defendant's much better off with James Daly calling the shots and not him. But that's not where we are.
I was at the jail again yesterday and talked to Mr. Stover. And to give this court a little background, Mr. Hartung and I had been working on a possible resolution of this matter. I talked to Mr. Stover about it. He appeared to be angry about that. It's very difficult to have a conversation with him because he keeps wanting to talk about other issues that aren't relevant to what's going on right now.
Also, Mr. Daly, let me just cut you off there. If Mr. Stover does not want you to speak on your behalf, I think we did address this at the arraignment, that you had been appointed as a special public or standby public defender. So at this point, let me just ask Mr. Stover, you have previously advised the court that you want to represent yourself.
So just for your keeping score, he was appointed as counsel and or standby counsel. So the standby counsel, I suppose, can come in at any time. He was trying to help this guy. He was trying to get a plea bargain for him, it looks like. This guy just will not cooperate. So then that doesn't mean that Daly's out. That just means that he's back to a standby, and then this guy's handling it himself. And that sort of...
Mr. Stover, is that still the case?
Your Honor, at our last court procedure when you were out sick, we talked and you stated at that time...
Defendant sounds oddly like Barack Obama.
...that you had granted me the opportunity to have new counsel appointed to the special. I advised you at that time that I was representing myself due to the inefficiency and ineffectiveness of counsel in the beginning all the way through the proceedings. So I do not feel confident because he socializes with the prosecution. So that being said, I prefer to have counsel that is in no way, shape, or form affiliated with Lenawee or Jackson County if I'm going to have special appointment from counsel.
Well, isn't that special? He not only wants a special counsel appointed, which he gets. James Daly's apparently that, because he says he has conflicts with everybody else because of his criminal past. But he wants to name exactly who it is. Well, it doesn't work like that. You have right to counsel, but you don't just get to choose any attorney you want on the planet. It's not how it is.
I just to keep the record clear, I have just recently on 10/30 of last month received my tablet privileges to be able to start to use LexisNexis to start the procedure processes for litigation. So I've been deprived of my Sixth Amendment due process in the beginning of these matters, dated all the way back to July, and even in beginning of the late June when I was incarcerated. With all due respect, Your Honor, I'm requesting at this time that I can address the court in judicial notice, and I request presence physically in the court.
That's interesting. He's demanding to be physically present in the court, and the judge handles it right here. And he's saying for judicial notice purposes, which is just silly. That's not going to get him anywhere. This whole time, he seems to be teetering on a sovereign citizen thing, but he doesn't say anything that's definitive. He's got bad ideas. I don't know if they're that particular strain. I still haven't. Let me know in the comments. Is he sovereign citizen or just a guy with bad ideas representing himself?
I wasn't able to understand the last part of what you said, the last about 5 words, what you were requesting.
What I was requesting is if I can be present in the courtroom so that I can implement judicial notice for facts that are pertaining to this case, because as of this point in time, we've been wasting time and expense at the court and the people, as well as me being incarcerated unjustly. I respectfully request that I have the opportunity to be physical in court today to address judicial notice issues.
All the time wasted pretty much can boil down to him fussing about attorneys and not accepting any representation and asking for other appointments and all that sort of stuff.
They're adjudicating facts pertaining to this case that are generally known by all persons involved.
All right, we are here today, Mr. Stover, for a pretrial hearing. We're not adjudicating any facts or finding any facts at this point. There is not, Mr. Stover, please let me finish. There is not a right for you to be physically present in the courtroom for a hearing such as this. If we get to a point where
that's interesting to me. When he raised that, I actually wondered.
have a trial, you'll be physically present in the courtroom for that. You'll be physically present in the courtroom for anything that you have a right to be physically present in the courtroom for. At this point, what I indicated to you at the arraignment, the previous hearing on this matter, is that I would look into the issue of the public defender issue. I do not have the right to tell the public defender's office who from their office or what special public defender will represent you. I don't have the right to pick that person. The public defender's office does that. If you have a disagreement with the person that they have appointed for you, you can contact the public defender's office and request that someone else be appointed, or you have the option to hire a private attorney.
Your Honor, with all due respect and no disrespect, the first thing is adjudicative notice is something that must be heard, and it can be heard at any proceeding throughout the procedural process due to the law. The law clearly states that's the fact.
No, I mean, he's just wrong here. He's trying to, he's got some fantasy going in his head that he can circumvent the trial by showing up and saying slick things, calling it judicial notice, and having it all go away. It's not like that. It just isn't. That's not the procedure.
I know for a fact that I have contacted the Office of the Public Defender, and they do not answer back. And they said back on the 14th of July on Zoom in Jonathan Ford's courtroom that at that point in time that it was a conflict of interest when they had standby Murphy and as my attorney, and then they tried to implement Mr. Daly as my attorney illegally on behalf of an illegal attorney I never hired nor retained, David Goldstein out of Ann Arbor. And at that point, Hartung stated clearly on the record that there was a conflict of interest because the alleged witness in this case has had every public defender in that office at some point or another for an alleged crime. So Mr. Hartung went on record and clearly implicated that no one in the public defender's office could represent me. Now, as far as I would understand, that would also extend to a special appointment, because he is in fact a liaison and a part of the public defender's office. So there.
Judge explains this nicely, but all the judge can do is appoint the public defender's office. That's it. That's all he's got.
All right. Well, Mr. Stover, I'm gonna jump in right there and tell you that that's not correct. That's the entire point of having a special public defender, is that it is some person that is outside of the public defender's office. So the conflict issue does not carry over to the special public defender.
With all due respect and no disrespect, Your Honor,
Yes, he just said, with all due respect and no disrespect, Your Honor. I know it's a serious case, but they always get me at some point.
the issues for me have started all the way back from the beginning of this case. That's why I haven't had a fair opportunity to address these issues. Upon pretrial, I'm incarcerated at this point in time. I have not had an opportunity to gather my evidence to further better myself and prepare myself for further litigation at trial, if that is the direction in which I intend to take. We're here today.
Mr. Stover, I'm trying to get through the initial issue. You've previously requested that, or indicated that you want to represent yourself. Is that still the case?
Your Honor, with all due respect, I have requested counsel that's going to be competent and help me. Mr. Daly has not helped me.
All right, Mr. Stover, I've told you the situation with respect to the counsel. You have a special public defender appointed for you. You can use him, or you can request through the public defender's office that someone else be appointed as a different special public defender. If they decide that there's no issue with Mr. Daly and he can continue to represent you, then he is the person who will represent you. I cannot tell them or require them to appoint someone different for you. Your other option is to hire an attorney for yourself.
Your Honor, you cannot force me to keep ineffective counsel. You cannot. And I've already stated by submitting my financial information that I'm indigent. The court has to provide legal representation. If one
and as I have just indicated to you, Mr. Stover, the court has appointed the public defender's office and then a special public defender. That is the person who will represent you because you are indigent. Your other option is to represent yourself.
Lord, Father God, give me strength in heaven. I will keep Mr. Daly. I'm being forced. I just want the record to reflect that. I'm being forced.
Your objections and issues that you have raised are all in the record.
This is interesting, and it comes up later. Mr. Daly, I think, makes a wise strategic decision to not inject himself because he already knows the outcome of this hearing. It can only go one way, whether he's representing him or not. And he just thinks, I'm not going to get my client agitated right now. I'll talk to him later when we're alone and see if I can talk sense into him again. But I'm not going to try it right now. It's just going to disrupt things.
I would also like to address the fact, Your Honor, that we said that we were going to address bond on this day. I've been here almost 180 days, 5 months on paper for 6 months if you're including good time. I have not had a thorough opportunity to effectively gather evidence pertaining to these cases and the matters of this case as the prosecutorial side has done. It is a dutiful right to allow the defendant to be able to gather his evidence pertaining to this case, and I cannot count on Mr. Daly hiring resources due to the fact that he has been hired on by the public defender's office. He's not going to exhaust his remedies and he's not going to exhaust his financial pocketbook to go and to reach out for resources to attain the evidence I need for this case.
Yeah, no, he's not, and nor should he.
I have looked into that issue. You did raise the 180-day rule at the arraignment. I reviewed the file. It indicates that there was an order for a criminal responsibility and competency evaluation on August 12th. Findings on that order were ultimately made on October 15th. That's a period of 64 days. According to MCR 6.004, which sets out the 180-day rule, periods of delay resulting from proceedings concerning the defendant, including but not limited to competency and criminal responsibility proceedings, are not to be counted toward the 180-day period.
Correct.
So we are not at the 180-day period. But what I need to know at this point, Mr. Stover, is do you want to set this for trial now?
Your Honor, I don't mean to interrupt, and I'm going to answer the question if you will bear with me. I barely have any time to do anything, and my hands aren't exactly free here, so I can't go through things that I would like to. That rule is substantial under the fact that if they weren't finding many ways to prolong the litigated process, they've been prolonging this issue from the gate, Your Honor, and the reason I have requested judicial notice to these issues is because if you go back to the original time and set date of when this alleged offense was alleged against me, you will find that there are multiple violations pertaining to this case. And that's been the whole issue. When I tried to raise these issues in the district court level and clearly edified to the court that there's no complaining witness nor signature, there's no valid warrant here, there's no affidavit of probable cause that's even available. It hasn't been sworn on record before any judge, magistrate, or clerk before this court or any other court. And the fact of the matter is that in order to have a search warrant, which there is none present in these discovery, there's no sign of it, they would have had to go on record and get actual, they would have had to get permission from the magistrate and swear before her or the clerk. They didn't ever return any information. The search was invalid. You know, they don't have anything here stating clearly that their actions were warranted by any point in action. They arrested me at the placement of the hospital, and they never read me my Miranda rights and or my warning. They never advised me or read my rights. They arrested me, and I knew I was arrested when I got to the jail when they fingerprinted me. That right there told me that you're legally under arrest. And at that point, they illegally went and searched and seized property. I gave consent originally to my truck, but when they went to the home, they did not have consent. They didn't have a search warrant. They didn't have the CSRT team available to get any biological, or any type of fluids if there were anything to be at the crime. They didn't have a standby. They didn't have anything. They went in the house without permission. I'm telling you facts. These are all facts. And that the officer came to the jail. He checked my hands. There were no actual evidence of any type of violence or anything to my nature. I'm the one who called the police in the first place for the accident that occurred. I'm the one who took the procedural steps to make sure the welfare of the alleged victim was intact.
All right, Mr. Stover, I appreciate all those things that you're trying to tell me. So right now, you've got a couple of options. One, if you want me to adjourn this for another pretrial so that you can either through yourself or have Mr. Daly file motions to raise these issues that you're raising, because I am having a difficult time trying to understand a cognizable argument that you're making, or we can set this for trial.
Your Honor, I would like to address. I would like to have a fair opportunity to address these issues because they're pertinent to the case. I don't know why the process has been drug on so long. I understand if there was an affidavit of probable cause that was signed.
Right, Mr. Stover, do you want me to set this for another pretrial so that you can file these motions, or do you want me to set it for a trial?
Yes, Your Honor.
It's an either or. Do you want me to set another pretrial, or do you want a trial date?
Do you want A or B? Yes. Oh.
Yes, pretrial, Your Honor, to file motions. And I would just like the record to reflect that Mr. Daly has already specified to me that he will not file any of the motions that I requested.
Because they have no merit whatsoever. I don't know all the underlying facts, but I'm confident in his assessment of the situation.
And I also am asking, Your Honor, to address the issue of bond. I have not had a thorough opportunity to be able to go and to gather any evidence in this case on my behalf. It's an injustice. All right.
First, can you just let me get through setting a pretrial date? We're going to set that for December 22nd at 10 a.m.
I do apologize, Your Honor. I'm not trying to be difficult. My anxiety's high. I've been incarcerated for so many months, and I've been dealing with a lot of things and injustices I have not really been able to thoroughly understand. So I do apologize for the anxiety. My life's on the line, and that's really all I can truly say to justify the fact of my anxiety at this time. I would like to state, Your Honor, that this, I haven't even had a probable cause hearing in these matters.
We find out later he waived the probable cause hearing.
A lot of things are bothering me, issues. They have no evidence in this case.
All right, Mr. Hartung, is there anything that needs to be addressed from the people's side?
Your Honor, we're just going to adjourn this till 12:22 at 10 o'clock at this time for a continued pretrial and allow them to file motions as they deem necessary.
Correct.
I'm satisfied at this point. Thank you.
All right, Mr. Stover, what is it you'd like to say about the issue of bond?
Your Honor, first and foremost, I'm not a flight risk. I'm not on parole or probation with any courts or anything of the nature. The fact of the matter is the bond is truly excessive in the fact that if we're going to address it appropriately, we have to look at the facts of this case, and there is no evidence. They have towels. There's no weapon. There's nothing of that nature that would implicate in that regard that there is some form of violence on my behalf. The people have yet to prove such elements.
Well, the allegation is you hit somebody on the head with a hammer.
When I was on parole, I successfully completed my parole without any violations during the whole duration of my tenure of it. I was always on time. I didn't miss any of my appointments. When it comes down to the facts of this case, I would really appreciate an opportunity to be able to go and to get the evidence on my own behalf, knowing that I don't have the resources, but I do have the ability to go and to gather it all. And I'm asking that I be able to do that, because if I don't, what's going to happen is the process is going to carry on, and I won't have an effective opportunity to present my case and my defense effectively later on down the road. I know that if there was an issue of people wondering if I'm going to show up, I'm going to show up. My mother, who's present in court today, comes an hour and a half every time to go to court, there and back, 3 hours total, every time for me. And I know that if I was released to her custody, she would make sure that I was here. I don't live in Anchorage, Michigan. I live in Detroit, Michigan. And I beg the question that if she's going to make this trip, would I make the trip? And I know in my heart, mind, and soul I would. I want to get this put behind me. I have a life. I had 2 jobs that I worked when I was outside of here. And I've lost a lot of opportunities based on being here. The 8th Amendment clearly states that an individual is innocent until proven guilty. At this point in time, excessive punishment has been rendered on me. I've been sitting here pretty much in isolation this whole time in a level 5 maximum security prison, if you will. I'm asking for the opportunity to be able to take care of what I need to on my behalf so that I can better prepare a defense. It's very important. I don't have the money. We were not rich. We've established this. I haven't lied about my financial situation in any way, shape, or form. I'm not going to contact the victim. I haven't contacted the victim since the last time they alleged that I have contacted the victim. I'm not at any risk here to do anything illegal. I'll follow the procedures of the law. I just want to be able to have an effective opportunity to represent myself fully with the assistance of counsel. And I know he's going to be my lawyer. I get that. But I can do certain things to help him better prepare himself for my case. It's very important.
I will surprise you here and say he actually did better than I thought, in the sense that he mentioned relevant things. It was a rambling mess where he was going on and on, but he's saying, I'm not a flight risk. I don't have a violent past. So that's true. I mean, we've got a violent allegation and then drug offenses in the past. I mean, that's a fair thing to say. Those are all reasonable things. He just could have pared that down into a more cogent presentation. But unlike usual, at least it was rational. I see where he was going.
I have the money to do anything other than that, Your Honor. I'm not going to run. I want to show up the court. I want to prevail and prove my innocence in this case. I promise you.
All right. Mr. Hartung, do people have any position on the request for a reduced bond?
Yes, Your Honor. So clarification point before I talk about the bond is, I believe Mr. Daly is his attorney, and I believe he should speak through his attorney. And I don't believe that has changed at this point in time. With the court's permission, I will address that, but normally I would address comments from the attorney.
I like this. I actually agree with the prosecutor. It's an awkward scenario where the defendant's speaking for himself while represented. But I understand why the defense attorney's doing it, and Olsaver just wants no part of it. He's not like really mad. He's like, whatever. He just ignores it. He's like, just do what you got to do.
Specifically about this particular issue. So bond has been reviewed on numerous occasions in district court. And I don't believe the bond has ever been changed. It's been reviewed by Judge Poor. It's been reviewed by Judge Shadler. We did have dates set up for an exam to be actually held. We had witnesses in the courthouse. We were prepared to go. Mr. Stover was not prepared to go and disrupted Judge Shadler's courtroom to the extent that we could not have the hearing that day. He was subsequently ordered to the forensic center. That was completed. We came back again for hearing dates in district court. He waived his preliminary examination at that time. Law enforcement understood. He has a right to remain in that case.
Sorry, Mr. Hartung. Mr. Stover, I'm going to ask you not to interrupt Mr. Hartung. He didn't interrupt you. I didn't interrupt you during your opportunity to speak, so I'm going to ask you not to interrupt.
And he has a right to have that exam remanded if he wants to. He absolutely has that right. But we do believe, law enforcement believes, that he is a danger to the victim. The victim was struck in the skull with a hammer and opened a hole in her head.
Your Honor, this is an alleged
Mr. Stover, Mr. Stover, I just asked you not to interrupt Mr. Hartung. If you do it again, I'm going to mute your microphone. Do you understand that?
Yes, Your Honor. It was an alleged offense.
Mr. Stover? All right, Mr. Hartung, please continue.
The only other thing I want to say, Your Honor, was he has numerous prior felony convictions, which I think is a factor in the bond setting. There has been no new information from the time of district court that I'm aware of that would cause the court to in any way change the bond. Thank you.
Your Honor, if I may, before you rule on this, please.
All right, I'll give you a brief opportunity, Mr. Stover.
When we did come to court for the preliminary examination, the reason, first of all, why I didn't want to go through with it was because literally.
All right, Mr. Stover, I'm just going to interrupt you for a second. I'm not. What happened with respect to someone's choice to have or not have a preliminary examination is not something I'm going to weigh in terms of making a decision.
No, I was just trying to make it that the alleged victim did come to court and refused to testify multiple times. Every time they subpoenaed the alleged victim in this case, refused to get on the stand. Not because they were willing to get on the stand. Never, not once. And you know, that's the whole issue of this situation. When it comes to the felonies in my life, yes, they were drug felonies. I did never go to prison ever in my life for a felony of violence, ever. And there's no implication that I have been an obsessively violent criminal. There's no factual basis behind that. My charges have been from drugs, and I went to prison for that. And like I said, I haven't been a threat to the community. I haven't been an agent in years. I have not been here. I came here under different pretenses, and when I was here, I was a working student. I have proof.
Okay, I've heard that, and I'm going to cut you off at this point because I need to move along. I don't think that any additional argument is going to result in something that I haven't heard already. I am not going to change the bond at this point. I think that the bond is appropriately set. I have had an opportunity to review the Lenawee County records with respect to Mr. Stover's criminal history, and I think that that supports the notion that bond is appropriate where it's currently set. 14-17125 case was a case where Mr. Stover was charged with assaults to great bodily harm, 2 counts of resisting and obstructing, and 2 counts of assault with a dangerous weapon. That case included a bench warrant for failure to appear. He ended up pleading guilty to the assault, great bodily harm, an R&O, and a felonious assault. The register of actions on that case indicated that there were 2 violations of probations in that case, and was ultimately served a prison term. I think that in addition to the very serious allegations in this case and the fact that it is a potential life offense, give the court concern about Mr. Stover's appearance at future court hearings, and so I think the bond is appropriately set. I'm going to deny the request to bond.
But Your Honor, where's the evidence in this case? Where's the evidence?
I've made my decision, Mr. Stover. You can tell the officer that's with you that you're done in court for today.
Where's the evidence? That's the question. Where's the evidence? I haven't had due process.
I've made my decision, Mr. Stover, on the bond.
I mean, that's just the basic stuff right there. Where's the evidence? Evidence is presented at trial.
You can tell the officer that you're done in court.
I love you, Mom. Thank you for coming. I love you with all my heart. Don't worry. Everything's going to be fine. They reap what they sow. Against the law. It's truly against the law.
Well, there you have it. Our good friend Judge Oldsaver, he got a little cranky there, and rightfully so. Very appropriately so. But the prosecutor, I thought did a nice job. Daley would have done a great job if he'd been allowed to. I noticed that too, because he sits back and he just gets out of the way. Part of that is to be comfortable, but I think part of that is very calculated by him. He knows when he's got an agitated client like that injecting himself is just going to make things worse, and he's completely selfless in that regard. He doesn't care that they're calling him ineffective or any of that stuff. He knows he's effective. He's in this stuff. I mean, he's been doing this for years. He's heard this nonsense. He doesn't care. So everyone's doing their best. I just thought that hearing was fascinating. It was a little funny in some of his approaches, the judicial notice nonsense and a couple other things in there. But no, the underlying offense was pretty serious, and the arguments were pretty serious. They had to set another date and address bond yet again. But it looks like they got their other date, and Daley's back on, but is he going to be driving the car when it comes back up? That's the question. Here at Law Talk, we like to have fun with silly stuff that happens in court, and every once in a while, and completely by accident, I assure you, you might learn something. Thanks for watching.